Welcome to Sports Wise, a podcast about sports and the law with your host, me, Gabe Feldman, director of the Tulane Sports Law Program and co-director of the Tulane Center for Sport. On this episode, I'm joined by the most prominent sports lawyer that you've probably never heard of. His name is Jay Reisinger, and he has represented some of the highest profile professional athletes in the country in league disciplinary cases, salary arbitration cases, and crisis management. If you're a pro athlete and you're in trouble, he's the man to see. Jay joins the pod to talk about the Stefan Diggs and Christian Barmore criminal charges, whether they might be suspended during the NFL playoffs or the offseason, and he gives a behind-the-scenes look at how the leagues investigate and punish athletes. Here we go. Before we get to the interview, just a quick note that we recorded this conversation the day before the NFL playoffs started, but most of you are probably listening to this after the first weekend of the playoffs. So Jay and I are not ignoring the first round games. We just don't know who won them yet. On to the interview. Welcome to the podcast. Jay, thanks so much for coming on.
Thanks for having me, Gabe.
All right, first question. What does the J stand for in your name?
J-A-Y.
It's not like Jay Peterman?
No, it is not. It is J-A-Y.
Yeah.
Named after my grandfather.
Okay. That was an inside joke between the two of us because you and I have known each other for a very long time. I went back and looked, and I think the first time we were ever on a panel together was in 2008 at the SLA conference. I moderated a panel basically on the same issue about commissioner discipline.
Yes.
And you, I think, had been practicing for about 20 years, and I had just finished high school back in 2008. So that was...
There's not that much difference between us, but thank you, Gabe.
All right. Thank you for coming on. We have a lot to talk about. I want to just quickly talk about some of the salary arbitration work you do in baseball, and then get into the Stefan Diggs, Barmore issue and what criminal liability and league discipline they might face. But just to kind of give people a little bit of background on you, and I have said this probably since 2008, you are the lowest profile, high profile sports lawyer in the country. You've represented so many big names in sports, and yet you manage to keep a low profile. It's pretty amazing that it's continued. Rattle off some of the highest profile cases and folks that you've worked for.
Sure. I was lucky enough when I graduated from law school to get a job with a lawyer here in Pittsburgh. His name was Sam Rich, whose brother Tom Rich at the time, so this is the late 90s, was one of the highest profile hockey agents and baseball agents in the country. And by virtue of working with his brother's sports agency, I started to handle disputes related to professional players, both in hockey and baseball, and was immersed in the world of salary arbitration, which is a large part of my practice today. And as I told you prior, we just finished salary arbitration exchange yesterday. But, on a usual year, I handle about 30 different individual major league players' salary arbitration matters, most of which 96% or so settle prior to hearing. But when they don't, I litigate those. And I've been doing that really since 1998. And so I have a great deal of experience in that. And through that practice, I was introduced to members of the Major League Baseball Players Association back when it was run by Don Fear, and later by Michael Weiner. Both the Major League Baseball Players Association and the National Hockey League Players Association have hired me as outside counsel related to drug matters, PED matters, domestic violence matters. And I continue to do work for the MLBPA as a consultant in salary arbitration. I guess my first big newsworthy case happened in 2005 when I was part of the group that represented Sammy Sosa before Congress. Shortly after that, I represented Andy Pettit when he was subpoenaed. I'm sorry, he wasn't subpoenaed. He was invited to testify in front of Congress under threat of subpoena. And, as a result of the PED hearings, et cetera. I represented 13 players in Senator Mitchell's report into the use of performance-enhancing substances in baseball. And so I have a sub-practice in which I represent players that are accused of using performance-enhancing drugs. And I've been doing that not only at the Major League Baseball level, the NFL level, and the NCAA level. And I also have been involved in a number of domestic violence cases, both in Major League Baseball and in the National Hockey League. I've represented NFL players in disciplinary hearings before Commissioner Goodell. And I also like to sail and fish.
Your highest profile are Alex Rodriguez, Sosa, Andy Pettit.
Yes.
Okay. And as you said, you have as much, if not more, experience in these types of cases, whether they are the PED cases or disciplinary cases, and then specifically domestic violence cases as well. And that brings us to why I wanted to have you on, is although it's kind of very quickly been pushed out of the news cycle, but as tends to happen, but Stefan Diggs and Christian Barmore were both separately charged with criminal offenses. And I would love to, because this is not something I've really covered much on the podcast, but it's something that I used to cover a lot and still cover in my classes. But the dual or the parallel proceedings that might end up going on, one, the criminal proceedings in our criminal justice system, there may be a civil case, but then two, any potential discipline from the NFL and how you navigate, and you're not, as I understand it, representing Diggs or Barmore, but how one who is representing them would deal with an NFL investigation and a criminal investigation going on at the same time, and what Bills fans, Stefan Diggs fans, Christian Barmore fans can sort of expect to come next. And as we know that we're on the eve of the NFL playoffs, it sounds like nothing is going to happen, at least in the short term. But can you walk us through kind of the nature of the crimes that both have been charged with, and then how that might fit into any discipline and what the disciplinary options might be?
Yeah, the NFL is somewhat unique in that the commissioner's office can conduct their investigation on a parallel track with the criminal investigation. And as any good lawyer would say, the most important aspect for both of these gentlemen, right, is their freedom. And the commissioner of the NFL, no matter how hard he may try, can't take away your freedom, but he can take away your paycheck and take away your right to play the game. And in the NFL, and I've represented a few NFL players in disciplinary hearings that had been charged with criminal offenses. And it's somewhat unique and different than Major League Baseball, certainly, but also different than the NHL and the NBA. The commissioner can actually interview you related to the allegations that have been made while the criminal proceeding is ongoing. And that creates, for a lawyer, it creates a problem. Because if you don't cooperate with Commissioner Goodell's investigation and you don't submit yourself to an interview, at his discretion, by the way, he can suspend you without charges being proved, et cetera. And that creates an issue about how you handle the criminal case, because anything that you technically would say in an interview with the commissioner's office is not privileged. And therefore, in theory, state or federal authorities, depending on who's investigating the matter, in this case, it's the state, they in theory could subpoena all participants at that non-privileged interview with the commissioner or the commissioner's designee, subpoena them for notes, subpoena them for testimony, and that can interfere with your pretrial rights as a criminal defendant. And so it's a dance that you have to navigate, given that you also represent a professional athlete who makes his money, his livelihood, and the continuation of his career sometimes is highly dependent upon submitting yourself to that interview. Right. So you have to weigh the risks of having a non-privileged interview with the commissioner's office and participating or cooperating with their investigation, because it may affect negatively your rights as a criminal defendant in the state case.
How does that differ in the other leagues? What do they do um, to not present that potential conflict or exposure to discovery and revealing information so you don't get suspended, but then you might get in criminal trouble?
The seminal case in Major League Baseball, there was a seminal case from 1970, an arbitrator decision regarding Ferguson Jenkins. He of the Hall of Fame. Ferguson Jenkins was arrested in 1970 in Toronto for drug possession. And the commissioner at the time, Bowie Kuhn, demanded that he submit to an interview in front of the commissioner's office. Jenkins, who by the way was a Canadian citizen, but Jenkins' Canadian lawyer, Brian Greenspan, who's represented a lot of high-profile athletes and other criminal defendants in Toronto, refused on Jenkins' behalf, refused to have him submit to an interview prior to the criminal case being tried. Kuhn, using the best interest of baseball clause, attempted to suspend Ferguson Jenkins. It was immediately grieved by the Major League Baseball Players Association, and an arbitrator ruled in that case that, you know, when a player or a member of the collective bargaining agreement is facing criminal charges, he does not have to sit for an interview with the commissioner until those charges have been resolved. And it's called the Jenkins rule now in parlance. And so when you have a player, when the commissioner's office in baseball tries to interview a player on certain matters, and I've had this, you assert your Jenkins rights, your right to not talk. It's basically the Fifth Amendment in Major League Baseball. In the National Hockey League, they don't have as many matters such as this, but the commissioner's office is almost always deferred to the criminal process being played out before they adjudicate their own discipline. And the same with the NBA. So it is a little bit different. And the other thing is, in the other sports, you have the right to take those to an independent arbitrator, which you don't have in the NFL.
The final discipline.
Correct.
And that was, as we both sort of lived through, one of the big issues, ancillary issues in collective bargaining agreements to the last two times around with the NFL, where the players were trying to eliminate that difference and try to make it so that there was a completely independent arbitration system so that the commissioner didn't get to do the investigation, the discipline, and then the appeal. And they were able to modify it, but it's still not quite what the NBA, NHL, and Major League Baseball have, but at least there is a level of independence. It's just not the final say for the NFL. So in this case, where you have the criminal charges, what the NFL could do a lot of different things potentially, but Diggs and Barmore, as I understand it, are going to play in the playoffs, and there's not at least been any public discussion of a suspension or any sort of disciplinary action. What do you think is happening now, and what do you think the process looks like for the two of them?
It's interesting, and the timing of it is also interesting, right? I mean, these allegations didn't come to light until early December. Well, in Diggs's case, I guess they came to light on the police report was filed on the 18th of December. The incident allegedly occurred on December 2nd. In Barmore's case, it's my understanding that the incident took place sometime in August and was reported a week or 10 days later to the authorities, and neither one of them has been placed on the commissioner's exempt list, which the commissioner has the right to do. He can put them on the exempt list, in which case they get paid, but they cannot play. Now, I would imagine that what has happened in the meantime is that David Meyer is representing both players, who's a very talented lawyer from the Boston area. You know, he has significant criminal law experience. He's the former chief homicide prosecutor for Suffolk County and has represented individuals and institutions in Title IX cases, and also represented a defendant and won an acquittal, I believe, in the Varsity Blues case. I think what they most likely have done is made some prima facie disclosure to the commissioner's office related to these incidents in which their clients' innocence or claims of innocence have been put forth with some supporting evidence that has led the commissioner to not take immediate action, and especially at this late date, I mean, that could have a significant impact on the players specifically. I mean, that's really what's important. But of course, it also has significant impacts on their teams as they're both playoff teams. So I think what the commissioner's office has done has they've at least reviewed these cases and determined that there is at least some credible evidence that perhaps there's a defense or to the claims that have been made against them by the charging authorities.
And that would be based on the police report and public evidence and whatever their lawyer presented and weighing all that. Is that, or do you think they've done any, they haven't questioned the players as I understand it, but do you think they've done any additional investigation, or are they just relying on public reports?
No, my guess is they've done their own investigation. I mean, oftentimes, and this goes with baseball and football and hockey, they'll send investigators out. I mean, they've got private investigators that, they're not on retainer, but they have private investigators in every NFL city, every Major League Baseball city. And so they will call, those investigators, they will call, the police reports, they will get supporting documentation. And this happens more in baseball, but I mean, Major League Baseball, their Department of Investigations has an office in the Dominican Republic.
Right.
And they will send investigators out to try to interview witnesses to the extent possible, and try to gain as much information, not just through the public records procedure.
And what's the timeline for that? Because as you said, this didn't become public until December. We're now second week of January, playoffs are upon us. Is that something the league would typically do immediately, or you tell me, how long would that process take, particularly given, and then maybe you can also explain, because I think the general public probably doesn't exactly know what the commissioner's exempt list is and kind of where it came from, and all the player discipline cases in the early 2000s and Ray Rice and all of that. But
Yes.
But so that's a lot that I just threw at you. But one, in terms of the timing, and then two, if you can talk about this sort of interim step that the NFL has at its disposal.
So the interim step that the NFL has at its disposal is that they basically can suspend the player, but they suspend the player with pay. And so when you suspend the player with pay, his rights vis-a-vis the collective bargaining agreement are somewhat mitigated because he's still getting paid. He just can't play. And so the commissioner's exempt list is an easy way to put somebody on suspension without putting them on suspension formally.
But what's the standard to get placed on the commissioner exempt list? What rights does a player have in terms of trying to not get on? Because even though they're getting paid, it still could be significant damage if they're taken off the field.
Sure, and especially in football, that especially because many football contracts are incentive laden, right, on games played. When you're placed on the exempt list, it's your base salary that you get paid, and the same with Major League Baseball and the NHL and the NBA. They have different forms of the exempt list that you often see that in Major League Baseball. If a player has been accused and the commissioner's office determines that there's credible evidence that the player may have committed a violation, let's say, of the domestic violence program, they can be placed on a similar list, but they still get paid. And we've had players in Major League Baseball that have been paid for a season, right? While they sit on the sidelines. And now the teams aren't a big fan of that, right? Because they're still paying the player and they're not receiving the services of the player. But it's a stopgap measure that prevents you from facing certain arbitration. Now, in Major League Baseball, you can be placed on what is tantamount to the exempt list for a period of 10 days. And if you don't agree with your placement on that list, I mean, Trevor Bauer went through this, a number of other players, you can actually then appeal that to an independent arbitrator for determination as to whether your placement on the commissioner's exempt list is appropriate. Your rights under the NFL personal conduct policy are somewhat limited in that regard, much different than they are in baseball. There's not really such a list in the National Hockey League. There is such in the NBA, but as a player, you don't have, if you're placed on the exempt list, you have the right to appeal it to the commissioner's designee, which is not necessarily an independent arbitrator.
And so in this case, as you said, that there would appear to be some evidence for the commissioner to have determined that he was not going to place these guys on the commissioner exempt list. Does the fact that we're at the beginning of the playoffs, do you think that plays a role at all? That the standard would need to be higher before you're going to take someone off the field in the playoff?
Well, I let's face it. I mean, the NFL is a business, and when you take players on playoff teams on the eve of playoffs away from those clubs, you affect the competitive balance of the playoffs. And I think that the NFL, it's not like they're the beacon of morality. That's not it. I mean, this is a business decision, and they don't want to affect if this would happen at a different point in the season and they became aware of it at a different point in the season, perhaps the outcome might be different, because then they would also have time to conduct a real investigation, while the players are still being paid, if this happened in training camp, et cetera. But given the fact that it happened on the eve of the playoffs, I think they're playing it safe, keeping those players on the field. It's not like they're a danger to society, it's pretty hard to tarnish, the NFL shield as an individual player. And I think that they're willing to put up with whatever negative PR may come from that, as opposed to facing, look, I mean, the commissioners in every major sport work for the owners. And if you take away a key piece of a playoff team from Robert Kraft, for example, Commissioner Goodell is going to hear about it. And so I think in that case, I think they're playing it probably a little more cautiously than they would had it happened at a different point in the season or the year.
So do you think it's possible if they get knocked out of the playoffs, or the Patriots knocked out of the playoffs, that the investigation then picks up and we might see some action early in the offseason?
Yeah, I think that's possible. But at this point, they probably are going to wait to see how the criminal process plays out. They have arraignment dates coming up, I believe, in February. The other thing at the outset, I noted that, at least in Diggs's case, this was a dispute apparently related to pay from a personal chef. The incident occurred on December 2nd. She didn't report it until December 18th. And same with Barmore. The incident with his mother's child, occurred sometime in August. She didn't report it to the police until 10 days later. And as just a matter of practice in these cases, there's always, not always, but often a civil side to it, where there's been threatened litigation.
Right.
And so the lawyers that are representing these women, if they are represented, and I don't know that for a fact, but oftentimes they will not have their clients talk to the NFL or the NFL's investigators, because they want to protect their own potential civil case. And I'm not saying that's the case here, right. But that's been my experience, that oftentimes the internal investigation conducted by the leagues can be slowed down by a potential civil suit on the part of the aggrieved party.
And there's obviously nothing the NFL can do to those witnesses. They don't have any jurisdiction over them. There's no stick or carrot that they can offer to them, as opposed to the player, who could be, as you said, suspended. And in this case, let's just assume, and let's take Diggs and Barmore out of it, and just say the hypothetical player who is faced with similar charges, and let's say it's not during the playoffs, whether it's the offseason or middle of the regular season, and the commissioner asks for an interview with them, and they or their lawyer say no because of the potential criminal exposure. Any discipline at that point, is that discipline for failure to cooperate with the investigation, or is that discipline based on the underlying merits of whatever they're charged with?
It can be both, right? So if you refuse to cooperate with, if the commissioner, if Roger Goodell says, I want to see you in my office on Tuesday, and you're going to tell me about everything that happened, and I'm going to make a determination, and you say, no, I'm not coming, he will suspend you, period. And he'll suspend you for failure to cooperate, right? And then what can happen is, if either their internal investigation or ultimately the criminal charges are played out, then he'll take that into account on top of the failure to cooperate.
Right.
And so when a player is faced with that choice, almost 999 times out of 1,000, the player is going to submit to the interview, because if you don't and you're suspended without pay for failure to cooperate, you're, depending on how long that investigation takes, you're not getting paid and you're getting older. And especially in the NFL, where your careers are so short,
Right.
That can be the end of a player's career. Now, conversely, if the allegations and what is found to ultimately be found it is serious enough, sometimes you have to, as a lawyer, advise your client that no matter what the professional ramifications are for you,
Right.
the criminal implications are far worse, because, as I said before, I mean, Commissioner Goodell can take away your paycheck. He can't take away your freedom, and juries and judges can take away your freedom. And so you always have to keep the player's criminal exposure paramount, while trying to balance that with the professional ramifications, both within the league and outside of the league, especially for PR purposes. A lot of these guys have endorsement contracts, et cetera, that have clauses in them, morals clauses. And, when you fail to cooperate with a league investigation, sometimes they can invoke, endorsers can use their morals
Right.
clause, invoke it to terminate your contract in that regard.
So that 1 in 1,000 could be a case where the charges are so serious that it's just not worth the risk of cooperating with the commissioner's investigation because of the implications it might have or consequences it might have for you criminally. What about the athlete, though? I
Well,
assume
I
this has
mean,
to
when you
be
take that to its extreme, right? Aaron Hernandez, who David Meyer also represented, right? I mean, you're accused of homicide, and you're not going to submit your client to an interview with the commissioner
right,
because you're looking at life in prison. So
right,
yeah,
right. Let's take the other end of the spectrum, and let's take an athlete who is completely innocent, believes that they are completely innocent, believes that whatever they've been charged with is untrue, but does not want to subject themselves to an interview with the commissioner, and the commissioner suspends for failure to cooperate, and then they are, whether they're acquitted or they're exonerated or whatever, it turns out that these were not valid charges. They were completely innocent. You mentioned that when they are suspended that they could appeal to the commissioner's designee, and I would imagine in most cases that appeal does not go well for the player because you're appealing back to the person who suspended you to begin with.
just with a different name. Yes.
Right. And again, that's been part of the criticism of the NFL disciplinary process for a long time, is
Yes.
that they're not given the same process that you would be given in really any other disciplinary setting. And whether it's Tom Brady or others who have challenged that and saying that this is unfair and they're being deprived of due process. And the answer the courts have generally given is you only get the process you bargained for. And this may seem like a crazy process, but you agreed to it as part of the CBA. So this is all you get. You don't get a second bite at the apple and trying to get greater procedural protection. But there are, I think, I think the Steelers were one of the teams, whether it was in 2010 or more recently, that said, we don't want to sign this CBA that gives the commissioner this power. But it would seem, and then let me know if you disagree with this, that the majority of players said, we don't think we're going to get in trouble. And so why would we trade anything for greater protection for athletes who do get in trouble? Why would I give up $1 for a neutral arbitrator if I'm never going to be disciplined by the commissioner? But sometimes that player is disciplined. And that nobody thinks, most people don't think they are going to end up in front of a disciplinary hearing or in jail or wherever it might be. So for that truly innocent athlete, what do they, what does it not happen? Or is the innocent athlete that the process works so that the commissioner wouldn't suspend them or would be able to determine their innocence due to their investigation?
Well, first and foremost, right? If you're suspended for failure to cooperate and ultimately you're exonerated, right, in a criminal court, you're not getting your money back. It doesn't work that way. And as you know, almost every time, especially in the domestic violence context, right? And this is not limited to professional athletes. It's not limited to professional truck drivers. It's
Right.
domestic violence cases have a way of going away. And it's oftentimes because in the heat of the moment, the complainant makes the complaint and then makes a decision later on that they don't want to prosecute the matter. Now, in Major League Baseball and in the NFL and the NHL and the NBA, the fact that you're acquitted, right, or the charges are dropped
Right.
in a criminal case, or even in a civil case that's dismissed via a settlement, that doesn't preclude them from disciplining you, because they can find that your actions, well, perhaps not criminal, right, or violative of the specific policy. Now, in the NHL, they don't have a specific domestic violence policy. It's a general player conduct policy. And they've, the union has fought hard to keep it that way. And again, they're not faced with it much, as much as in baseball and basketball and football. I've represented a number of players that have been disciplined despite the fact that no criminal charges were ever brought, because the complainant makes certain allegations, and under the Major League Baseball, domestic violence program now, as it's been rewritten. I'm not going to say why it was rewritten, but oftentimes you enter into a confidential settlement agreement with the complainant, whoever it may be, and it's a violation of that settlement agreement for them to provide information to Major League Baseball, or anybody else for that matter.
Right.
If you do that in Major League Baseball now, Major League Baseball has the right to request any settlement agreement that you've entered into. And they oftentimes have used that for the basis of discipline. Why are you paying so-and-so $200,000 that have made certain allegations about you, and that now is clammed up? And so they can use that as the basis of discipline, despite the fact that no criminal charges were brought, if it comes to their attention.
Yeah, and I mean, that is a key point. I'm glad you raised it, because specifically with the NFL, it's very clear, and it's been clear for a while, that you can be disciplined for something that is not a crime, either because you are acquitted or because it's not criminal, that it's just something that is detrimental to the image of the league. And whether that's something you've said, whether that's a slur or something that, again, we might think is bad, but
John Rocker.
John Rocker, yeah. There are not as many cases as there used to be, it feels like, in terms of discipline for speech, but that there's no question that the leagues can discipline you even if it is not criminal, or even if no criminal charges are filed, or even if they are filed and you're acquitted. But I'm just sort of stuck on this idea that the commissioner can suspend you for failure to cooperate when your failure to cooperate might be based on potential criminal exposure, or might be based on the fact that you didn't do anything. Now you say, well, if you didn't do anything, why wouldn't you go cooperate with the commissioner? And you might say, well, because why should I have to potentially implicate myself when I haven't done anything? And I don't think that gets talked about a lot. That sort of, commissioner exemplis, I think most people who are familiar with this process in general knows why it's there, how it's been used, and that it is this interim measure to protect the player. At least they're still getting paid, but it also protects the league by saying, we're not going to have you on the field because we think this is serious enough that there might be something to it. And that investigatory power, just thinking about the Tom Brady case and the destruction of his cell phone, which, like, I know I can't look at this through an unbiased lens because I'm a lifelong Jets fan, but in that case, I know I can see the sympathy in your eyes, but in that case, I don't even think it's alleged, I think it was admitted that he had destroyed his cell phone during the investigation, and the argument was that he always destroys his cell phone because he's Tom Brady and there's lots of potentially sensitive information in there. And I get that, where the commissioner might say you've obstructed the investigation, but the idea that the league essentially can force you to cooperate or discipline you for not cooperating seems to me to be a sort of one step further
if you go to work at a law firm, right, they're not going to conduct an internal investigation if under these circumstances, unless it involves like an employment-based situation, right? I mean, if you're having trouble with your wife at home and you're not
Right.
creating problems at work,
Right.
they're much more in tune to that. But look, the players ultimately are the ones that have the power, right, to change it by virtue of negotiating in the collective bargaining agreement. And you raised a really good point earlier. Every player, to a man, that's not going to happen to me.
Right.
I'm not going to do that. That's not going to happen to me. And you see that a lot. Unlike the NFL and Major League Baseball, you have guaranteed contracts, and along with those guaranteed contracts, each contract has specific guarantee language in it, right?
Right.
That says, if you are convicted of a felony, if you are convicted of DUI, et cetera, it's a violation of this contract, and therefore it's no longer guaranteed. Now, in baseball, you have the right to negotiate that language, right?
Right.
And some teams will negotiate individually the standard guarantee. It's called STP, the standard guarantee language in each individual contract that is required to have a guarantee. And oftentimes, really good agents pay attention to the specific guarantee language and try to negotiate that language. I do a lot of standard guarantee language review and comment as part of my practice. But to a man, the player that you're negotiating on behalf of, when you get stuck with the club, and your right is to not sign the contract the way it's written, right? I mean, that's the player's right. I've never heard a player say to me, despite best efforts, you're right. I might do that. So I don't want it in my contract. That's never going to happen to me. And then all of a sudden it does. I've negotiated with a fellow Tulane salary arbitration competition judge who was an executive at a club who had inserted a death clause into his club's guarantee language that if you die during the time of your contract, that it was a violation of the guarantee provision. And we were able to eventually prevail upon the commissioner's office that this club was a little out of line, despite the creativity of my fellow judge in inserting it. But it came after the terrible death of the Angels pitcher, not Tyler Skaggs, but the Angel pitcher was killed in a car crash, and he was under a guaranteed contract that the club still had to pay, and we got that thrown out. A player has the right to just, especially high-powered free agents. I mean, Kyle Tucker and others can say, I'm not signing this, right? I'm not coming to your club if you're going to require me to sign, this onerous language. And again, good agents will just do it. And usually you should do it before you agree to the contract, right? Because the other thing is, once the player has the money, like on his doorstep, he's going to sign whatever you put in front of him, generally speaking. But yeah, I mean, they have to make individual decisions, but they have the right, the players in every major sport, to implore upon their union. I mean, but it is a give and take. I mean, in order to receive those rights, to receive the independent arbitrator rights that Major League Baseball has, the NFLPA would have to give something in return for that. But that's also what's made the Players Association of Baseball the strongest union in sports, because they do have solidarity behind them. I'm not being critical of the NFLPA or the players or the attorneys that work diligently, on behalf of players there, but it's just a fact of life, that the commissioner has always had the upper hand in those negotiations. And so therefore it remains ultimately in Commissioner Goodell's hands almost entirely, no matter which way you slice it, as to determine the appropriate discipline of players. And there really is no meaningful right to have that reviewed. And that's unfortunate. And, but again, the players have the ability to change that if they decide to do that.
And it's interesting because there is certainly some historical context for why the Major League Baseball Players Association has been not only the strongest union in sports, but for a period of time, people have said it might have been the strongest union in the country. And I think part of that is because of the early leadership. Part of that is just circumstances, but part of it is also because they couldn't sue under antitrust law for a long time. So they had to be a strong union because they had no other avenue to try to get benefits. And whereas the NFLPA and MBPA and these player associations that did bring antitrust suits to be able to get free agency, baseball players never had that option, at least until relatively recently, and they haven't exercised it. But the other thing I just want to ask you about, we didn't talk about this before, so you may not have thought about this, but you are a big sports fan. You're a college sports fan.
Yes.
You surely are following what's happening with college coaching contracts and buyouts and what's happened here in my home state of Louisiana, where LSU fired Brian Kelly, had to pay his massive buyout. The governor said that they would never do that again. And then within 2 weeks, they had done it again with a bigger buyout. And not only that, in hiring their new coach with no offset. So not only do you have to pay him, but there's no offset if he gets hired somewhere else. Putting on your player slash coach representative hat, your agent hat, or your reviewer of these contracts hat, that there are some coaches who just clearly have tremendous leverage because there aren't that many consistently successful, let's just do football, college football coaches. And so if you are a Lane Kiffin, then you have a lot of power in that negotiation, because if LSU is not willing to do it, then maybe Florida is, or maybe Penn State is, or whoever it might be. What would you do if you were if you got brought in to consult to maximize the leverage, that not only to maximize the terms in the contract? What would you advise a college coach or their agent to say, look, you can be negotiating not only more money, not only a higher buyout, not only no offset, but what else would you be pushing for if you were advising that coach?
Complete control of the football division. And so especially in the wake of, NIL, et cetera, many major colleges have basically what, GMs. And what you want is as much independence from the institution as possible, so that you can run the football program the way that you want to run it without interference from the institution. I mean, that's a big part of it, because that is important. From what I understand, I've negotiated contracts on behalf of several NHL head coaches, and it's different in college, especially in college football, to a lesser degree college basketball, because Lane Kiffin was going to get, I mean, he was the hottest coaching prospect. Of course, he's been the hottest coaching prospect on and off,
right,
for the better part of a decade, and has never left a good taste in anybody's mouth when he leaves. But institutional control, the absolute right to hire and fire your assistants without, and a lot of pro coaches in the NFL and other leagues want the same. They don't want the general manager of a team saying you have to fire your defensive coordinator, you have to fire they want complete and utter control. And of course, then it comes to player personnel selection. I mean, the Pittsburgh Steelers are an example. Mike Tomlin has a significant amount of say in player personnel decisions. Whether that's right, wrong, or indifferent is not for me to say.
Yeah.
I will be going to the playoff game on Monday night, so it will, I'll let that, speak for itself. But
yeah, again, as a Jets fan, I didn't know there were NFL playoffs. I didn't know that anything happened after that final game of the regular season.
You did have Western Pennsylvania native Joe Willie Namath play for you, like back in the day. I mean, you won some games then.
See, this shows our age difference. I wasn't alive for the Joe Namath era.
Well, I wasn't. Well, I guess I was. I was 5. But Joe Willie Namath, man, he came to one of our. We had a neighborhood legal services fundraiser. We had all the Hall of Fame Western Pennsylvania quarterbacks come, and Joe Willie Namath was there.
That's awesome. Joe Namath is my hero. I have a bunch. You don't see him on the screen, but I have a bunch of Joe Namath signed pictures in my office.
Well, I have my Dan Marino helmet because I'm also a Pitt fan. I was brought up to root for Pitt and hate Penn State and Notre Dame, which is why Fedorov and I don't get along. But yeah, you want institutional control. The no offset. The no offset. I've negotiated that in one NHL head coaching job, and I did that once, and that was it. Clubs are just like, no. I mean, but baseball players have offset, clauses in their contracts, right? I mean, you get released from a guaranteed deal. you have an obligation to take another, job, which, they always get, but at the major league minimum, right? So the old club's still paying. But the
Right.
fact that there's no offset, I mean, Charlie Weiss, was the founder of that. It's a good time to be a college coach agent. I mean, CAA, et cetera, are making millions, and for coaches that aren't coaching. The no offset, to me, it just continues to surprise me because, I mean, Charlie Weiss was getting paid double after he left Notre Dame, right? And was continuing to get paid for the better part of 6 years, I believe, when he
So,
went and took an NFL job.
so do you think it could ever get to the point where, let's say Lane Kiffin, or just, we don't have to use him specifically, but let's call him Kane Liffin, has 4 great years in a row, wins 4 national championships, and
Never gonna happen, but okay.
but just that, it's hypothetically, and then his deal is up and he's negotiating and he's got a bunch of different offers. Do you think a coach like that, one in a million coach, would be able to negotiate for a buyout even if they're terminated for cause? Do you think they would ever make it a truly guaranteed contract? Maybe not 100%, but that if you're fired without cause, you get 100%. If you're fired for cause, you get 50% or 40% or whatever it might be.
The answer is yes, in this context, the definition of for cause. And I've negotiated that in coaching contracts before. They often come to you with an expansive for cause, right? I mean, it's in almost every employment agreement. Here are the definitions of for cause. So in the college ranks, you often have, if the coach is found responsible for a violation of NCAA, rules or policies, right? That's a for cause termination. Those things can be negotiated. I don't think any sane institution, of course, I'm not sure that there are any left, but they'll never get away with just saying, if you're fired for cause, we're still going to pay you. But the coach has the leverage to seriously minimize the definition of for cause.
Right.
And that's where a good agent makes the difference, or a good lawyer makes the difference in doing that. And you can reduce the for cause pretty significantly if you have the leverage that Lane Kiffin, for example, had. And I'm
Right.
sure that they did that.
And it is, for people who are listening, it is pretty fascinating to go and at the public schools, these contracts are publicly available, and you can look at the terms of their contracts, and it is fascinating to look at the for cause provisions and how they differ, and how some of them are, could be 4 or 5 pages laying out every specific thing, and it's often in response to what happened to the coach prior to them. And they
That's
said,
right.
we're never going to do that again. We don't want to have to fight about whether we have the right to fire them for cause. And so they list every variable. And we, as when we were junior lawyers, and I'm sure you were taught this in your contract class or negotiation class, that you often want to keep things vague because it's just so expensive to negotiate the details on the front end. So you're almost better off waiting till the back end. If there's a dispute, all right, then you can litigate. But rather than spend all the time and the money on the front end. And it's not the case now with these provisions, because they are so heavily negotiated for the most part on the front end, where there is not uniformity, where you have individual contracts, that it is pretty amazing to see what a school is trying to protect against, and how much leverage a coach has versus a school. So for those of you who are either bored or want to interesting area to focus on, the for cause language in different employment contracts. It's pretty fascinating.
It is. And you're also finding that now in NIL deals,
Right.
right? I mean, schools can terminate certain NIL deals, right, for cause, and some
Right.
can terminate them at will. I mean, in this day and age, it certainly wasn't this way even 3 years ago, where now an athlete has a college, an NCAA athlete has leverage to negotiate the for cause language in their NIL deal, right? I mean, a lot of them have, if you enter the transfer portal, despite the fact this is a 2-year agreement, we
Right.
have the right to terminate. And so good agents in this marketplace are negotiating on behalf. And of course, depending on the value of your player in that marketplace, you have far more leverage to negotiate those kinds of provisions and lessen the impact to your client.
Well, thank you, Jay. This is awesome.
I've enjoyed it.
I don't like to say nice things about you, but you're really good at what you do. I have to say, and the proof is in your long and storied client list, and you've been doing this as long, if not longer, and better than everybody else in the industry. So, congrats on all of your continued success. Look forward to seeing you back down in New Orleans. Here's my final question, though.
Yes.
What is the one no what is something that you read or listen to that is not sports related that makes you smarter?
The New York Times.
Okay, all right, fine, that's not a major news publication. I thought you were going to say the New York Times, but other than that, it could be a book you've read at one point, or
I read.
you're a romance novel guy, aren't you?
I am not a romance. I'm a spy novel guy.
Okay.
My reading of I'm a big fan of history, and so I enjoy. I just finished Hampton Side's most recent book about Captain Cook, and the things that I learned about technological evolution, such as the Greenwich Mean Time and the self-winding clock that were instrumental in his circumnavigation of the globe in the 1700s. Those are things that make me smarter. I enjoy reading about things that I don't know a whole lot about. Again, I'm a history buff, but I try to read things that I don't know about so that I at least broaden my very limited horizons, Gabe.
Well, I'm glad you preempted me. I was about to say that, but you did it for yourself. But Captain James Cook, we've got the other James Cook playing this weekend. I appreciate, Jay, again, your friendship, your support of Tulane's baseball arbitration competition and everything else. Look forward to seeing you again soon and love to have you back on.
You have the best sports law program in the country, and you're the reason for it. And I wish you guys nothing but the best in this competition. I'm sorry I'm not going to be there this year because I have 6 real salary arbitration cases that I have to prepare for in 2 weeks. But all the best and continued success, Gabe.
Thank you, Jay. I appreciate it.
All right, man. Take care.
Yeah, thanks. Thank you so much.